Welch. He's a partner and chair of the real estate group at Frankfurt, Kernet, Klein & Sells. He regularly advises on purchases, sales, leases, and financing of a wide range of commercial properties. In addition to real estate transactions, Mr. Welch works with the litigation group. During the COVID-19 pandemic, he has provided pro bono advice to tenants. He's co-chair of the Prep in Real Estate Alumni Committee of the Prep for Prep organization that prepares students of color to attend private schools. Mr. Welch received his JD from Fordham University and a BA from Vassar College. And now I'm going to turn it over to you, Larry. Thanks again.
Thanks, Diana. I appreciate it. I wish I could see you all in person, but maybe that's another month or two away. As Diana said, I'm a partner and chair here at Frankfurt Kernet, and I was invited to speak with you by judicial title. So I thank you for joining and for giving me an hour of your time. And I thank Judicial Title for graciously agreeing to host the CLE presentation. I hope you find it thought-provoking and useful. So the title of this CLE presentation is, as you can see, Retail Lease and Guarantee Agreements, Pandemic Updates. I'm presenting Larry Welch. It was prepared with my paralegal, Jana Teffy. And let's get into the program. So what brought this to mind for me in terms of giving the presentation was a Slate article that I read a couple months ago. And I love the headline, which was, "Your lease is bad because your landlord found it online." And the article, which you'll find in your supplemental materials, it was sort of a look at residential leases in Philadelphia that a couple professors out there, David Hoffman, Anton Stresnev, reviewed, and they analyzed a ton of leases based on 2 decades of eviction filings. What they found, most leases are not good for tenants, they're getting worse. And not to pick a side, landlord versus tenant, I think what we saw in the pandemic is at the end of Mr. Hoffman's quote, where he says, contracts have been transformed by technology, more contracts over more terms. It's just everywhere. And he says the contracts we sign are just bonkers. And that, more than anything, I think reflects what we've practitioners seen over the past 2 years is, doing a deep dive into a lease, whether in the beginning of the pandemic or a few months in, and looking at the lease and the guarantees, all hundreds of, sometimes 100 pages, 150 pages, and realizing that, oh boy, some of this is bonkers and it doesn't necessarily reflect what's going on right now. So I thought about that article, and I was thinking about, specifically the New York City market, because we had an interesting sort of situation, being not only the ground zero, so to speak, of the pandemic, certainly for longer than we'd like to remember, but as we enter the 2-year mark and we're about to go back, come back to the city, and we're about to reopen businesses without mask mandates, et cetera, we have to think about, what caused New York and essentially most of the world to shut down. And as we think about those topics, think about were the leases and agreements that we made and that parties made prior to that, why didn't they help? Not only, they didn't help tenants, but they also didn't help the landlords either, because, no one really, I think, contemplated this sort of event happening. And secondly, the leases just were all over the place. So what I saw some forums, some of them, they just weren't clear representations of a meeting of the mind of the landlord and the tenant, and in some cases of the guarantor. And not just in a pandemic environment, but in a pre-pandemic environment. If you think about how this happens, let's think about real estate and how we get our forms. I mean, we're lucky in New York City. I think we have a lot of great providers of forms and form leases. City Bar, you have Westlaw, you have Rebney, and the forms are really good. But for a lot of practitioners, we really haven't looked at our forms in years. It's probably been 5, 10, 15 years since we really looked at the forms and looked at the riders that we have. And you've seen it, and there are time crunches for deals. There's a competition to get into, to sign the deal as soon as possible. Pre-pandemic specifically, that sort of led, I think, to a situation where the documents, in some cases, and we'll go into more depth, in certain provisions, really weren't up to snuff and really didn't reflect what the parties wanted to agree on. So, I took a walk outside my office. We're in downtown Manhattan, and I saw this bar, restaurant, which apparently has changed its use, and it's a COVID testing center. And I think, for purposes of what we want to think about, this picture, I think, really captures a lot of the outside of the form deals that had to be made to, keep businesses open, to keep any sort of rent flow going to landlords so that landlords could pay their mortgages and taxes, et cetera, that we need to think about going forward when we draft. If you take just a look at that picture, you'll see a few things which are, the permitted use. We always talk about the permitted use and what the tenant is allowed to do or not to do. We say, well, a tenant can only do this or can only do that. But do we really think about what that means? I mean, does that apply even when, your restaurant can't open? It's usually an all or nothing proposition in these leases and riders. So let's think about that. Take a look also at the signage. We have what appears to be a temporary signage over what was probably a landlord approved sign. Do emergency situations like we had override the lease? And as we see in practice, a lot of times it does. But does the lease ever talk about that? The lease oftentimes is very silent on that sort of issue. And I have to, tip my hat to all the business people in the city who, sort of rolled up their sleeves and just made the deals work and made things work. But, we as practitioners, we need to keep up with that, and we need to be at the forefront. Our forms need to be a little, flexible enough to deal with that sort of situations, because, even if 80% of the landlords and tenants were able to, sort of come to a workable understanding, that's still 20% of the business population that, came to loggerheads over these sorts of issues, because they had no guidance in the leases. And it's sometimes hard to advise a client to act in a way that's contrary to agreed upon terms, as I'm sure you've seen in practice. Another interesting thing I thought about this picture was, it made me think about the carry out alcohol rules that the city implemented during the pandemic, which were a lifesaver for a lot of restaurants specifically. But that's the sort of use that in most leases was probably explicitly restricted. Generally it was, you could have liquor in accordance with law, but only for on-premises use, not for carry out, with no type of exception. And what you really want to do is go into your forms, look at some of the provisions we're going to talk about, including the force majeure provisions. Take a look at your riders. Are we just talking about delaying obligations, or are we talking about getting rid of obligations totally? And that's something that you need to think about, whether you represent the tenant or the landlord, so that whenever you have these situations, New York City's had our share. There's always something that we need to be able to give guidance to our clients. So I think the quote on the side, Jordan Barker at Bark Equities talked about the most notable change that he's seen negotiating retail leases has been the addition of pandemic clauses, and although the probability of those clauses of another pandemic is low, it's important to have proper rental protections in place in the event of another shutdown. We need to think about those what if scenarios, even if the likelihood of them occurring is small. Pre-pandemic, I think a lot of what we saw was, oh, we'll deal with it if it comes up. Don't worry, rent interruption or business interruption insurance will cover it. Don't worry, we'll work it out. That sort of negotiation, I think, went on, well before the pandemic. And just with the high volume of deals, sometimes that's one of those issues that I think that parties and practitioners would give on. But I think what we've seen, and as I'll continue to hammer on, is we need to be, forward thinking. We have had a bit of a lull over the past, year or two where the volume of deals has gone down. This is the type of lull where you want to, do your research, read the cases, really read your documents, read your agreements, so that, as things ramp up and we're doing, 3, 4, 5 deals a day, that you are able to feel confident that your lease reflects the understanding of the parties. Let's go ahead to the next slide. And what we saw, I think, a lot in the first few months of the shutdowns and the pandemic was, sort of disparate treatment of a lot of different types of leases. I think, when you ask someone, what type of lease do you do? Some people say they, we're in residential leases, or I run, garages, or I run restaurants, or I run, retail stores or offices, what have you. And sometimes it kind of gets lumped together, right? It's like, commercial leases, and there's no real differentiation between the retail and the office. And I'm not talking really in terms of the form, because there are office forms and retail forms and loft space forms and things like that. What I'm really talking about is the mentality that the types of protections that the parties need, again, not just the tenant getting rent protection, but the landlord up the stream getting rent to be able to pay their mortgage, and up the line getting mortgage payment protection and things like that. What I think we saw in the beginning was sort of everyone together, but then as the pandemic went on, different types of leases sort of got different treatment. So you had office tenants. If you were the attorney for an office tenant and you were able to obtain any abatement or rent abatement from an office landlord, then that's good, and that's a very nice landlord, I would say. And because I really didn't see that. I saw retail tenants to some extent, and especially restaurant tenants and certain other personal service tenants able to get more modifications of their leases. And we're going to get to why that occurred. But up front, everyone said, and let me take a step back. What is the difference between an abatement and a deferral? I'm sure you've had a lot of clients who went to landlords in the beginning, or you had landlord clients who gave out what they called, rent relief. And rent relief often took the form of one, an abatement, or two, a deferral, or some hybrid of the two. Abatement was basically the total cancellation of the rent for a specific period of time. It was probably March to June of 2020 when we had the really intense shutdowns for 3 months. So in that case, the tenant would never have to pay the abatement back. But then there were also the deferrals, and a lot of landlords gave out deferrals, and the deferral is more of a way of agreeing with the tenant that they don't have to pay the rent at that time on the normal schedule, but that they could wait to pay it, some length of time in the future. And landlords and tenants were very creative with that sort of arrangement, because the landlord for themselves knew that they would eventually receive the money. And up the stream again, and you always have to remember this with leases, up the stream, a landlord's lender also knew that they weren't really losing the money. I mean, it was sort of it's just deferred. They'll get it at some time. Whereas when a landlord went to a lender and asked for an actual abatement for their tenant, the lender may not agree to that sort of relief. So always be aware of the difference between abatement and deferral. And in this case, think about, if I have an office tenant client, how will they be treated not only by their landlord, but in this case, by the government? So in New York City, if you recall, there were certain reliefs that came down the line. Among them were the guarantee protection laws that came in New York City later on. But before we get to that, let's think about the sort of, what did people think was going to happen? I think, when most tenants went to landlords in the beginning and they say, hey, this crazy thing is happening, I have to shut down. The response, and I think the response from a lot of landlords, and I think it was a genuine response, was, it's okay, just call your insurance company, call for your business interruption insurance, and make the claim. They'll pay the insurance policy back. And as we've seen in most leases, especially retail leases, there's a requirement that tenants obtain this sort of insurance, where either business interruption or rent interruption insurance policies. And that often comes up when, tenants would negotiate abatement rights, pre-pandemic, when they would, if I can't use my space because the landlord doesn't do this service, or because there's a water leak, or because of any of a myriad of reasons that prevent me from operating my business, what should I do? And I think a lot of landlords and us attorneys said, well, don't worry about it as a lease negotiation issue. You are going to get your insurance, your business or rent interruption insurance, and they'll cover us for the term, whether it's usually 12 months or what have you, for the length of the payout. And I think a lot of practitioners sort of relied on that. Depending on your tenant, you may have pushed a little bit harder to get abatements for certain situations, water leaks, lack of service, those sorts of things. But whether you were foresighted enough, perhaps from the SARS outbreaks in early 2000, maybe the tenant did negotiate for some sort of additional abatement in the event that business and rent interruption policies didn't pay out. I think you should, when you have time after this presentation, take a look in your packet and read this case, 10012 Holdings Inc. versus Sentinel Insurance Company. It's a Second Circuit Court of Appeals case that touches on some of these issues, not just the business interruption insurance, but also, what is a casualty? How are pandemics treated in terms of casualties? Let's take it back to the lease. When you think about the lease negotiation process, there comes a point where the tenant delivers insurance policies, and this also applies, for landlords when they enter into mortgages and loans. And oftentimes, the lender or the landlord requests to see insurance certificates evidencing insurance in certain amounts and certain types, right? When coronavirus hit and COVID-19 hit and the pandemic hit, I think for many business parties, they pulled out their policies and the hundreds of pages of riders attached to those policies, not just the certificate, but the actual insurance policy. And lo and behold, in many of the policies, there's a rider, and a lot of times it would say, sorry, no coverage for viral or bacterial or communicable diseases or pandemics, and contagious diseases. And I recall, seeing that in the first few months of the pandemic, when people were calling and asking what they should do, and first thing they had to apply for their claim anyway, but every single one of them was getting rejected on those grounds. Not only that, but as the case that I cited, the 10012 Holdings case indicated, is that you actually needed actual physical damage to the premises, at least under the specific policy that tenant had. So we were, I think, certainly in New York, where these exclusions were probably in most people's policies, the tenants were at a loss at that point, where you had, not only are you not going to get your business interruption insurance, because, COVID-19 is some sort, a viral disease or communicable disease. So you have that exclusion. But there was also a lot of debate and discussion and arguing over whether, the government ordered shutdown or even the presence of coronavirus particles in your building constitutes the type of physical damage to the premises that an insurance policy would cover anyway. And, this is one of those areas of law that I think the exclusion for the pandemics and diseases part, that'll probably stand up, because, whatever the insurance says and whatever the parties agreed to, it's pretty unambiguous that there are those exclusions. But in cases across the country, you'll see that not every policy had that sort of exclusion. And there are a few courts that have said that, the actual presence of coronavirus particles or germs or what have you constitute, physical damage, or it's the type of argument that could be made. So I'm very interested to see how that part plays out over the next few years. In the meantime, though, taking it back to the lease, this is a reminder that going forward, landlords and tenants cannot be complacent and believe that whatever insurance policies we're talking about, whether it's business interruption or casualty or liability, that they sort of act as a magical cover for situations like coronavirus or like some of the other issues that come up, which prevent not only one business from operating, but multiple businesses from operating. These sort of catastrophic events, hurricanes, terrorism, et cetera, that come up. And we really need to read these forms in that manner and think about each item. I mean, no one wants to go through a force majeure clause when the landlord just wants to rent their space starting tomorrow and the tenant is ready to get their business up and running. But we, as the lawyers and practitioners and the brokers, we need to really take a close look at what is in these insurance policies, what is in our force majeure clauses, so that we don't have situations like this going forward. You should keep in mind, I remember early in the pandemic, there was some pressure to have state bills passed to cause insurance companies to pay out certain policies. I don't know that any of them have been successful, probably, especially not in New York. I think the plain language of these virus exclusions and disease exclusions probably will prevail. But as the last 2 years have shown, I've been wrong with my predictions many times. So we'll keep an eye on that going forward. So continuing on the topic of the force majeure sort of force majeure, business interruption. Force majeure clauses were another item that came up. Some people call them, act of God clauses. And this didn't just come up if you represented tenants, but it definitely came up if you represented landlords who had to pay mortgages and such. As you know, force majeure clauses are just ubiquitous. They're everywhere. They're in probably every contract that's ever signed nowadays. And but then we learned from some of these cases and some of these situations that the force majeure clause sort of vitiated certain defenses that may have been available to tenants anyway. So first of all, if you haven't seen the force majeure clause, usually it says if some sort of catastrophic event, and it could be listed and detailed, outside of the reasonable control or outside of the control of one of the parties, prevents that party from performing its obligation, that there will be, usually it says, a delay in the time frame for that party's performance, for the affected party's performance, which has been in agreements all the time, and it's usually been enough. But in this case, it was not enough. The payment of rent is usually excluded. The payment of monetary obligations is usually excluded from those force majeure clauses. And not only, tenants were blindsided by that, but I think a lot of landlords also were honestly, a little bit happy that that was the case, but I think a lot of them didn't know going into it that they would still or should still expect to receive rent during a force majeure shutdown. I've received many calls from landlords in the beginning saying, well, it's covered by force majeure. Am I going to get paid? And right there in the clause, it says, yeah, everything is delayed. Every obligation's performance is delayed except for that, payment of monies. So in that case, the balance really started to tip in favor of the landlords as opposed to the tenants. So that's when you really, receive those sort of frantic, what do I do? What am I supposed to do with this lease payments sort of calls and sort of situation? A lot of tenants look to the defense of impossibility or frustration of purpose, which relate to unexpected events that cause, to some extent, the inability of the contract or the agreement to really reflect the intention of the parties, or the ability of the parties, or the ability of one of the parties to get any sort of gain from the contract, which certainly in the case early in the pandemic seemed to apply to a lot of tenants. I mean, if I ran a retail store and the governor executive order said I could not open, I could not have customers, then it was impossible for me to accomplish the permitted use of the lease, which was to run a retail store specifically, right? So let's think about that in what I said earlier when we looked at the picture of the bar restaurant and COVID and the COVID testing center. Sometimes the permitted use clause itself interacted with the force majeure clause in a way that made clear what the purpose of the lease was, right? You have this lease is specifically for this permitted use. So when the tenant said to themselves, well, I cannot accomplish that permitted use, and my permitted use doesn't even allow me flexibility to change the use, to do other things permitted by law, which a lot of leases and lease writers had, it is now impossible for me to accomplish the performance of my end of the lease, or impossible for me to run my business in the way permitted by the lease. And this came up early in terms of the Gap Inc. case, or Ponte Gadea, which is referenced in on the PowerPoint, and also I put a copy in your supplemental materials. And I think this case is really a must-read case. It is, it really talks about, does force majeure specifying, government shutdowns mean that the parties sort of contemplated that that would happen, allocated the risk to one party or the other, in this case, the tenant, and does that does the inclusion of that government shutdown language in the lease vitiate the defense of impossibility or frustration of purpose? And in this particular lease, the court found yes, it did. So the court found that yes, the parties had contemplated, I guess you could read it, that they contemplated a shutdown by the government to the extent that it would be impossible to run your business, in which case GAP would be responsible, or a tenant would be responsible for payment of the rent or payment of monetary obligations under the lease. So I would wager, and you could read it many different ways. I'm not sure, and I hope that after this presentation, you will go and read your force majeure clauses and your casualty and all that stuff, and I will do the same, because I'm not sure that anyone ever thought about a situation like COVID-19 and its widespread impact, not just in the city, but essentially worldwide, and the impact that it would have on whether or not a tenant would have to pay rent. Because I again, just based on, working with a lot of landlords and tenants early on in the pandemic, I'm not even sure that the landlords fully expected to receive rent in a situation like that. And that's why they, called us and asked us to read the lease and read these sorts of defenses, because it's not I don't think it's intuitive that a tenant has to pay for something that they're not getting, regardless of the terms of the force majeure clause. But in any event, this case is a must read. Definitely take a look at it. And then let's think about the final point on that PowerPoint slide page. When you are negotiating your leases, especially for tenant, if the landlord is unwilling, or, and I underline, unable to provide services, if they're unable to do it because the government says they cannot, then that should not only be a tenant risk. If tenant cannot operate its business, they should not have to pay. That is the type of abatement provision that has been in leases for years, and a lot of tenants, depending on negotiating leverage, have been able to put in that sort of provision. Whether the provision of rent abatement is wide enough to cover landlords' inability to provide services because because there are no workers, because everyone has to stay home, or because there's been interruption of supply chains, all that sort of stuff has to be contemplated going forward. And you really have to say, would the landlords have accepted a 50-50 split of risk? I think in actual practice, you actually saw that with a lot of retail situations. They actually did voluntarily, to some extent, or outside of the lease terms, actually did agree and reduced rents and gave financial relief to tenants, even though the leases said that they didn't have to. But I think that if they had negotiated that in the beginning, I think in many cases the negotiation would have ended up on that point, which is, in the event of some sort of catastrophic, unexpected, situation like COVID-19, there probably would have been some sort of rent reduction or some sort of splitting of the pain, sharing of the pain, if not outright termination rights. So in any event, that's where a lot of it ended up. From the force majeure clause, you go to the related casualty clauses. You were there, I was there, you looked at every single clause, and you looked at every clause a lot of clauses that people hadn't looked at in years. And again, most casualty clauses generally required actual physical damage. Whether or not you're going to, physical damage contains, the viral particles being, within the premises. that's more of a case by case, lease by lease basis. But the gap case was, the judges in the gap case were very clear that in the gap lease, there was no reasonable reading of the casualty provision that could be triggered by the pandemic related changes cited by gap. So not only this case, there were other recent cases, at the time, recent cases in New York, which said that, the pandemic was not a casualty. I think across the country, I think there were, depending on the lease, depending on the court, there have been claims made that the pandemic actually was a casualty. But again, you would really have to read your lease, read the specific lease and think about it. I think the casualty clause actually may be one of those best places to put the pandemic clause that a lot of business parties want to think about, because there is a sense of, a shutdown period, a rent abatement period during a casualty. There is the sense that, sometimes lease terms are extended by casualty. There are times that a lease can terminate at the end, near the end of the term, if the casualty is of a certain magnitude, which really, I think, would have covered what I think a lot of parties would have expected in a similar sort of situation. But take a look at those forms and really dig in. I don't even know that the New York courts have a standard definition of casualty. I saw, in this case, they talk about, fire or other casualties. They compare it to singular events, as opposed to the, not so singular event that COVID-19 was, in the sense that it was such an ongoing situation and not just a one-day event. But I'm not even sure that that's really what separates inability to use the building. The inability to use the building, yeah, sure, is related to the government order, but for most businesses, for a lot of businesses, customers were not going to show up anyway, especially in the pre-vaccine days and things like that, especially early in the process. So parties should definitely look into those definitions of casualty. Maybe they don't apply. Maybe you want your casualty to really apply to what the insurance company policy defines as casualties. So, and that's fine too. But whatever decision you make should be a conscious decision that you're making, and not just sort of, it's in my lease form, so I sent it out. We can't be the type of practitioners where, you put in the names of the parties and you put the rent amount and the rent term and the address and you send it out. We really have to, use this situation that we've been in and really improve the practice. So after all of that was said, no relief under the force majeure, no relief on the casualty, no relief on the rent interruption insurance. If I recall correctly, that's around the time when this New York City Council jumped in, specifically for New York City, and specifically for a certain subset of retail tenant guarantors. So tenant guarantors, let's remember what that was. So you have a tenant entity, whether it's a limited liability company, corporation, or whatever, that enters into the lease as the tenant, gives some sort of security deposit, and then you have a guarantee behind it, often from a warm body or a natural person, or maybe some other well-heeled company above it. And the guarantee, you have full guarantees and you have hybrids and limited guarantees. The one that's specific to New York, I think that's a real New York specific guarantee, is that the good guy guarantee, under which the tenant gives an agreed upon notice, 30 days, 60 days, whatever, turns in the keys, surrenders the premises in the condition required under the lease, and not be in default at the time of the surrender. And in that case, the guarantor would be released from liability. leaving the tenant entity on the hook for, whatever lease damages, but the guarantor would be off. And in most situations, that's enough, because the guarantor is, just like you or me, a natural person trying to, make sure that they're not going bankrupt over a failed venture. What we saw with the guarantees, though, the guarantees didn't work. The good guy concept, the good guy guarantee concept really showed some flaws in the especially in the initial pandemic period. It's easy to give agreed upon notice, that you're going to turn in the keys, but where do you turn in the keys? The key, the manager wasn't, the landlord manager was not there. You're delivering notices to mail rooms that were empty. Surrendering premises in a condition required under a lease required, in some cases, getting contractors into a building to make restorations and removals. A lot of that wasn't even feasible. Not being in default at the time of the surrender, don't forget about continuous operation clauses. A lot of retail tenants are required to be operating, full time for a certain period of time. Well, they're shut down for COVID. Does that mean that they're in default by not being able to operate? Well, depends, right? Depends how it's written. And in that circumstance, the guarantee could be released from liability. So if the guarantor was able to meet all those conditions, which was difficult, if not impossible in certain situations, then they could walk away. City Council came in and put forth the relief bill that was signed by the mayor at the time, and I put the law in your packet as well, in your supplemental materials, but I'm sure you've seen it. But essentially, a certain subset of tenants who were especially affected by the shutdowns, whether it was the nail salons, restaurants, bars, things, retail of that nature, and certainly not the office tenants, even though they weren't really using their spaces, the guarantees were sort of made ineffective for a specified period of time. For defaults within that certain specified period of time. So essentially, the city council and the mayor decided that the guarantee, in some cases, didn't count. And it's not in a vacuum. That decision was certainly not made in a vacuum. And as you can see in the case Melendez, City of New York, that I referenced at the bottom, and that is also in your packet, you should really read through that one. Not just the majority decision, but the dissent. This case is not over. This decision is not over. But essentially, did the city council and the mayor have the right under constitutional state police power? And as a real estate practitioner, I haven't had to deal with constitutional law in a few years, since law school. But did it impact the contract clause, which was essentially the restriction that states not interfere with contracts between parties? So was the state allowed to say that the guarantee was being amended, or, as some people might say, terminated with respect to a specified period of time? And right now, that case, I think it was remanded to the initial court to review that again. But I would expect that issue to continue to come up over the next few months and years. In any event, what I think the guarantor relief did do was allow retail tenants and retail landlords to sort of come to a meeting of the minds in the new environment that we're in, and to sit down at the table and really think about what relief could be given to the tenant under the circumstances to allow, the tenants to continue operating at reduced rent, terminate the lease even without impacting some of their guarantee requirements. So I think the law did the law did spur that sort of cooperation between landlords and tenants. And I think, certainly from the tenant guarantor perspective, they're very thankful for that relief. Whether or not the law if it gets overturned, I would hope that there is no sort of attempt to claw back from the tenant guarantors who obtain relief. But that's, we'll see how that plays out going forward.
Hi, Larry. I'm just going to interrupt you for one moment to give the
Sure.
course code to everybody.
Okay.
The course code is FKKS. That is FKKS. And I will also type it in the chat. Thank you.
Thanks, Diana. So again, I think this case is a must read. Not only is the majority decision, the dissent are both excellent, and I think the points are both valid, and also it contains a summary, in the appendix of just the whole history of the pandemic, certainly between when it began up until the time of the decision. And in reading it, I really, it's weird how much has happened. When you sort of read it on paper, it's like, oh wow, I can't believe all that happened. But in any event, I recommend that you take a look at it. So as we wind down, there are some other lease guarantee provisions to consider that I saw when I looked through some forms and riders that were certainly implicated in the past 2 years, and I think you should think about them. So easy one, Yellowstone rule. If you're a landlord's counsel and you're still sending your rider with waivers of the Yellowstone rule, please, for the last time, remove it and delete it. The law that I put up there, Real Property Law 235(8), finally codified that you cannot waive the Yellowstone injunctions. So please take it out of the forms. And lender mortgage requirements. It obviously it's not in the lease, it's not in the guarantee, but a lot of landlords are not hard-hearted, or a lot of landlords are tenants too in certain situations, right? A lot of landlords are business owners just like tenants. But if a landlord enters into a lender mortgage requirement with a loan that was not forgiven, or with a loan that requires any sort of, lender oversight of lease amendments or rent abatement and that sort of issue, that can slow the process of amending leases when we have these emergencies. Most mortgages do not contain if there is a pandemic, you do not have to pay your mortgage clause. It probably doesn't, and it also says if you intend to give any sort of rent abatement or even deferral to a tenant, you need to come to us for consent. And again, in a situation where where it's not so easy to locate the mortgage lender or the servicer because of these sorts of catastrophic events, it's going to be hard to get any sort of approval done quickly. So any sort of agreement that you come to in the lease that allows these abatements, make sure that it's sort of carried over into the mortgage, so that the mortgage does recognize that abatement rate. There are a few other things, shuttle vans, gyms. Gyms were shut down early. Shuttle vans, like who would, no one was going in a shuttle van at that time. This really refers more to, shopping centers to an extent outside of New York mostly. But think about whether tenants were allowed to, was a tenant allowed to get a refund or a reduction for inability to provide. It may be covered in the operating expense clauses. It may be a certain standalone right, but think about those sorts of things. Again, the SARS pandemic was early 2000. We've had a couple other ones, and then we had this one in 2020. So it's not so unusual, right? It's happened three times in 20 years. that it should be thought about and added to your forms. Co-tenancy and anchor tenant rights in the malls. Does the fact that an anchor tenant closed its doors but is still in occupancy and continues to pay rent, does it mean that they're vacant for purposes of another tenant terminating their lease? You know, we had a lot of tenants who said, well, I have this right that if Gap Inc. doesn't have its doors open, that I could move out. But if you look closely at the lease, it doesn't really say that. It says that if it's, vacant, meaning if Gap Inc. is actually, terminated their lease and left and pulled their sign down, that's different than not operating, or so the arguments went, and what we want to do as practitioners is reduce that sort of arguing down the line. The more you argue up front and deal with up front in the lease process, when everything's nice and calm and normal, the less you have to deal with these issues when everything has gone off the rails, right? Because when it's gone off the rails, we're talking businesses in jeopardy. We're talking a higher stress situation, which leads to deals that might not be as equitable as they could be. The next one, make sure you take a look at those alteration rights, especially as it relates to emergency installations. All that plexiglass that we put in, all the installations of thermoscanners and temperature things, all the supply chain delays, all the inability to find contractors, all those items need to be sort of built in to say that in the event of some sort of emergency or force majeure situation, in that event, as long as I'm not messing with building systems, a tenant should be able to just, put that plexiglass up or install whatever installations they need or get whatever contractor they can find to come in and help them without, dealing with the endless process of, their insurance thing or because a lot of people had to do the work themselves or bring in a local handyman to help them out. So it wasn't necessarily calling their normal general contractor. They just had to find whatever help they could. Skip again, notice provisions. Is the recipient even receiving their mail? Not only because are they at the office where you're mailing it? Is the Postal Service even working at full capacity such that they can deliver it within the timeframes that we often deem to have been received by? Whether it's 2 business days after mailing or 3 business days, we need to think about that. That needs to, take a look at it again. Does it really make sense in this day and age to say that a USPS letter can be deemed received? And I would say probably not. Even, FedEx and UPS even had issues. So, whether it was related to staffing issues or, the COVID-19 general issues, even that was not delivering in the 1 business day period that we usually expected. Are executive orders the same as orders? So we have these definitions of legal requirements, and it's a long list, and we have to read it. But I looked at a few of them, and they say orders. And I think that for a lot of people, when they think of orders, they're talking about a court order. Or maybe they're not. Maybe they were thinking of executive orders from the governor or from the mayor. So let's be specific with that because, did we have 100 executive orders, 200 executive orders? Those all need to be covered in your legal requirement definition. Building rules and regs, take a look at them. The building rules and regs that we have attached to the forms, generally do not, they don't work. The terms are archaic, they don't match up with today's reality. In some ways, the building pass concept really needs to be changed. Does the building pass include the requirement that someone coming to visit you in the office or at your place of business have a temperature scan, their vaccine card, their mask, other requirements of executive orders, things like that? But I would argue that you need to change it to also allow people to bring their bikes in, especially, nowadays, a lot of people would rather take their bike than take the train or take the bus. let's move ahead in those sorts of items. Can you exercise your remedies? Can a landlord exercise their remedies? Look at the remedy clauses again. I mean, what do you do when the courts were shut down? I mean, what do you, not having an eviction ability is one thing, but not having the ability to even go to court is just not addressed. That's not, it was weird and incredible, but we need to, going forward, address that. And I think that, if I can't evict someone, if I'm a landlord and I can't evict the tenant who's clearly in default, should they pay me additional rent? Is it a holdover situation where I might get 1.5 times or 2 times the rent? Whatever it makes for, a good decision should be put in there if the parties will agree to it. But I think that sort of situation should be included in the holdover section. Outside seating areas and rooftops are obviously they were a lifeline for businesses of all sorts. I don't know what we would have done without that. But don't forget your ADA compliance. Don't forget that, just because you've set up shop on the roof or you've set up shop outside the premises, you still have obligations, ADA compliance, you have, cleaning requirements, that sort of thing. And as we sort of finish up the presentation, I'm going to touch on that outside seating area item again. And the last item on this list was the continuous operations, which I mentioned previously. So if you recall, continuous operations are seen where tenants are required to open every day for business or every business day or whatever. And when they cannot do that, how do we handle it? So I'm going to go ahead to our essentially our last slide. What's next? So, I feel optimistic. Everyone feels optimistic. The trains are crowded again. People are in the city. It's a great feeling. Some of the items I put in your packet, the permanent outdoor seating is becoming, is being discussed, and a decision will be made. I think it will be governed by Department of Transportation. The Sidewalk Cafe program was Department of Consumer Affairs. So I think they've changed it a bit because these outdoor seating areas are actually in the street. So DOT is going to be handling that. So keep aware of that. I put a link in your handouts. How do we deal with marijuana? How do we deal with gambling? Both legal in New York. Who knows? But look at your leases. I'm sure they're not necessarily handling it in the way that people would expect nowadays. Subscribe to our real estate alerts. I put our link there. And, I appreciate your time. I wish I could see you in person. Next time, I hope to do so. Thank you. Were there any questions?
Thank you very much. I will get to maybe just a few Q&A. I know it's 2:00, but I'll just go over 2 or 3 quick questions.
Let me, if you don't mind, I'll take some of the more straightforward ones.
Sure.
I like the Blumberg lease. I like the Rebney leases. I think they're fine.
Okay.
But that doesn't mean that you just read them and accept whatever's in them. No one's, they're not as up to date as today, right? Casualty force majeure applied to businesses affected by WTC. You'd have to take a look back at that. I haven't looked at that issue recently, but the force majeure, you obviously had physical damage, actual physical damage in that case. So it probably did. What is the status of Melendez? I think they've remanded it. I haven't seen what the newest part of the case will be, but keep an eye on it. You'll see the links in the document. To Storm IDA. So I will get to the next questions next time I see you.
Sounds good. Thank you so much for a wonderful presentation. We really enjoyed having you today. I'm already getting comments on how much everyone enjoyed it, so thank you. And just make sure that you send me back your affirmation, fill out the evaluation, and this afternoon I will resend everyone who attended all the material just in case you didn't get it. And thanks again, Larry.
Awesome. Thank you. Take care
Thank
all.
you.
Be safe.